Good afternoon, and welcome to Protecting Yourself from RICO Claims. My name is Justin Vogel. A little bit about myself. I'm a partner director at Garfunkel Wild. I've been here for 18 years. I have a little over 20 years of experience litigating commercial litigation disputes with an emphasis on healthcare disputes. I've got a lot of experience representing physicians, various other licensed medical professionals, and durable medical equipment providers against insurance carriers in connection with disputes over non-payment of claims. Over the past decade, I've been defending high-profile RICO claims against individual providers, large practice groups, and ambulatory surgery centers, and I frequently counsel clients on strategies to limit the risk of being named in RICO litigation.
And good afternoon. My name is Alexandra Wolff, or Alexa Wolff. I have a background of about 10 years of litigation experience. I've been at the firm here for several months, and prior to joining the firm, I spent the last several years investigating, drafting, filing these affirmative RICO cases that we're going to be discussing today, as well as taking examinations under oath, which again we'll get into during the course of today's presentation. Before that, I spent 6 years at the Nassau County District Attorney's Office, where I conducted more than a dozen jury trials, countless grand jury presentations, as well as pretrial hearings.
Okay, so let's dig in. So over the next 30 minutes, we're going to tell you a bit about RICO cases, specifically what a RICO case is, the steps that you can do to avoid being named in one, and what you do if you happen to be named in one. So let's start with what RICO is. Okay, so RICO is the Racketeer Influenced and Criminal Organizations Act, and it's generally used by federal prosecutors to bring criminal charges or by private entities to bring lawsuits for damages caused by racketeering activity. So RICO was originally enacted to combat organized crime, and really it was a way for federal prosecutors to get a whole group of defendants in at once and sort of break through the complexities of criminal organizations like the New York City crime families. However, even when RICO was first enacted in 1970, there was always a civil component to it. It's just that it was never frequently used. And the reason why was because it's incredibly difficult to organize in a pleading for a lawsuit. So when people tried to start bringing them in a civil basis, it was most often that the judges would look at them and say, listen, we're really going to reserve these types of cases for the people who know how to bring them, which is federal prosecutors for criminal organizations. But as time went on, and as civil plaintiffs got better and better at pleading the complexities of RICO cases, the judges started letting them go. And that's when it became much more important for medical providers, because insurance providers started to get wind of the fact that, hey, we can make these things stick in a civil context, and they've been bringing them more and more. So what are the elements of a RICO claim? So in order for a plaintiff to prove their RICO claim, they have to prove that the defendants participated in conduct of an enterprise through a pattern of racketeering activity, which is also called predicate acts, which means usually mail fraud or wire fraud, which causes injury to the plaintiff's business or property. Now, we're going to be touching on all of these elements, but we're not going to go into great detail just because it's so complex, and frankly, we're not going to have that much time to put it in for the half hour. But all of the things that we're talking about in this presentation will touch on the elements. And if anyone wants to get an in-depth discussion about the elements, they can certainly contact us or ask questions during the Q&A that follows the presentation. So why is RICO important to those in the medical profession? Well, since about 2020, there's been more than 300 civil RICO cases that have been filed against medical providers, medical supply companies, and different licensed professionals just in the Eastern District of New York alone. So that excludes cases that have been brought in the Southern District and other districts of New York. So we're really talking about quite a bit of litigation that's been brought. And the number of cases are growing because the insurers, like I said before, are finding more and more success, and they've become emboldened. And these types of cases are very attractive for the insurance companies because it allows them to group large groups of what would be seemingly unrelated defendants into one case. And we've seen cases where you've got doctors, large group medical practices, ambulatory surgery centers, DME companies, pharmacies, billing companies, marketers, collection firms, MRI providers, all put into one RICO complaint. And you often see it in the workers' comp or no-fault context because that's the industry where you have wide-based and large numbers of claims that are being billed at once. And it tends to lead itself to fraud and or fraud investigations. So we do see it most often in the no-fault and workers' comp arena, but we have seen it in major medical and other situations as well. And it's important to realize that RICO has a ripple effect. So the insurance carriers know that if you're named in a RICO case, you're likely to have a stigma that's attached to it. It's a federal case. It has a criminal connotation to it, even though it's being brought civilly. And it's a publicly filed document. So your patients can see it, other insurance carriers can see it, referral sources can see it. So the insurance carriers have a preference to sort of bring these claims as often as they can, where they can, because they know that it's going to drive settlement, and that medical providers are going to really try to get out of these cases as quickly as they can. It's also very cost effective for the insurance carriers because they can bring, like we said previously, a large number of groups into a case. And it puts a lot of pressure on the providers because a RICO case has what's called treble damages, which means that if you're found liable on a RICO case as a defendant, the amount of money that an insurer or any other plaintiff is seeking from you gets tripled. And it also means that even if you're in the case for, let's say, one claim that's at issue, you're in it just as much as someone who's in a case for 30 or 40 claims that are at issue. It's called joint and several liability. So it puts a lot of pressure on everyone to sort of play ball, for lack of a better word. It gets the insurance carriers the most bang for their buck. Now, another thing to mention is that RICO cases are generally never brought by themselves. They're usually accompanied by a RICO conspiracy claim, as well as state law claims for fraud and unjust enrichment. And the best practice guidelines that we're going to discuss apply to any of those claims that are going to be brought.
Now, Justin has just discussed kind of a broad overview of the RICO statute, its history, why insurance companies like it, and what benefits they get from bringing cases under RICO. So now, because of my background, I'm going to go over some risk factors that may get you on an insurer's radar. Now, this is not an exhaustive list. This is just some large patterns that I have seen over the course of my career. And after I go over this list, Justin can then discuss some best practices for ideally how to keep yourself off of an insurer's radar. So one of the first things that we see is if you have a large volume of billing. So for example, if you're billing millions of dollars over the course of a year or over the course of 6 months, if you're billing for very expensive services. So for example, for any patient, you're billing $3,000 per visit, $10,000 per visit, especially if you have an ASC or you're performing surgeries, you can end up submitting bills to insurance companies for $15,000, $20,000. And these, to insurance companies, when they're seeing these large bills coming in and that they're spending a lot of money reimbursing for these bills, that might put you on their radar. But that in and of itself is not going to be the only thing that would put you on their radar. So another thing that they'll look for are changes in patterns. So for example, if you have a habit of forming a practice, operating that practice for a short period of time, say 3 months, 6 months, closing down that practice, opening up a new practice, performing the same services or substantially the same services from the same location, and again, billing over a short period of time. So if the insurers are seeing these patterns where you're opening and closing practices in quick succession for no seeming reason, that might put you on their radar. Now, in addition to that, it's not uncommon to be put on their radar if you have a sudden spike in your billing. So for example, say, for a particular insurance company in the last several years, you've only billed this insurance company $50,000 a year. Now, all of a sudden in 2025, you're billing them $3.2 million. That sudden spike in billing is going to raise red flags for them, and they're going to take a closer look at what's going on. In addition to that, occasionally you would see a change in services. So for example, if you historically had always performed initial evaluations or consultations, follow-up exams, maybe some referrals for DME or, a chiropractic referral or something like that. And then all of a sudden you're billing for shockwave therapy, something you had never historically billed for. And now every patient coming to your practice is getting shockwave therapy or multiple rounds of shockwave therapy. That's something that might put you on their radar. In addition to that, they have the ability to see what percentage of bills, so the NF3 forms or your HCFA forms, you're being listed as the treating provider on. So if you are the owner of a practice and yet you are not the treating provider on the vast majority of these claims coming in, they may be suspicious as to who it is that's actually providing the services, who's supervising the services, and who's authorizing the services. In addition to that, occasionally, they will notice if you are submitting billing. Again, they can get this information from your HCFA forms and your NF3 forms. If they see that you're operating from a large number of clinics where you're seemingly not affiliated with them. What I mean by that is, your name's not on the door. You have a website, but maybe this location is not listed on your website. There's no indication from the outside of the building or even from inside the building that you operate there. So if you're, operating from this large number of clinics where you don't seem to have any apparent connection to them, that may be a red flag for them. In addition to that, sometimes you'll see that you would get put on their radar if they perceive that all of your patients are getting substantially the same treatment. And I don't just mean, you offer 5 services, so of course all of your patients are going to get those 5 services. What I mean to say is, the vast majority of your patients are getting very similar diagnoses. Then they're getting, the same referrals for pain management, or they're getting the same referrals for pharmaceuticals, prescriptions for the same pharmaceuticals, or prescriptions for the same types of DME, despite, their age, where they were in the car, what their injuries may have been. So that's something that may put you on an insurance company's radar. So some other things that may be considered in the context of getting on an insurance company's radar is the company you keep. And what we mean when we say that is, the offices where you're located, the other providers at those offices, or the billing company you use, or the collections firm you use, the marketing company you use, the advertising company you use. Even sometimes if you have somebody that you refer you refer to MRIs for, or pharmaceuticals or DME companies, if any of these individuals have a long-standing history or allegations of being involved in fraudulent schemes, that in and of itself may also be putting you on an insurance company's radar. Earlier, I discussed operating from locations where you have no apparent connection. So lack of advertising, right? So if you don't have a website where you list your operating address, if, in a Google search, you type your name and you're not affiliated with any offices, you don't have any social media, you don't have any phone number, you don't have any outside method to locate you or locate where your practice is, that's going to put you on an insurance company's radar. With respect to referral sources, insurance companies may end up looking at who is referring these patients to you for your services. Is it always going to be somebody that's also located at the clinic where you're operating from? If so, that would be a red flag. On the flip side of that, they may look at who you're referring your patients to. Are you always referring your patients to the same pharmacy? Are you always referring your patients to the same pain management doctor? Are you always referring them to the same chiropractor or for the same MRIs? These types of things may put you on an insurance company's radar. In terms of paperwork, they will look at, and this is where they will see patterns with respect to your treatment locations. who's providing the services, what services or goods you're billing for, what reimbursement rates you're listing on your bills. Because if those reimbursement rates are inconsistent with the CPT code, because either it's DME and you're able to charge 150% of how much you paid to acquire the item, or whether it's a pharmaceutical where there is no listed reimbursement rates, these are things that they will look at to see, is this provider someone that we need to look into further, or somebody that we need to put on verification because there's some red flags. The paperwork also, are the reports that you're submitting, are they fundamentally the same across the board for every patient? Is the narrative the same? Is the treatment plan the same? Again, are the referrals the same? Is the diagnosis the same? These are things that they will look at to determine if you should be somebody on their radar. And as I indicated before, that's how we're seeing the same treatment and services for the vast majority of patients. And it's on the billing and the accompanying treatment reports where the insurance companies are getting this information.
So those are all very important points, Alexa. But often, or you could follow each one of these best practices that we've gone through, and unfortunately, still end up on an insurance carrier's radar for potential involvement in a RICO lawsuit. So the question is, how do you know if you've ended up on the radar? And there's a couple of simple tells. The first one is, are you starting to get verification requests from the different insurance carriers? Now, what's a verification request? It usually comes up in the no-fault arena, and generally you'll get a letter from any one of the insurance carriers that says, hello, doctor. We see that you've submitted claims for X, Y, and Z patient. In order for us to process payment on those claims, we're going to need additional information from you. Once they've said that to you, that's pretty much a signal that they're not happy with something in your billing and they're suspicious. And that's why they're looking to go over all these claims. The verification request is generally going to be accompanied by a request for documents. If you start seeing a request for your corporate setup documents, your licensure, documents that refer to the billing practices and the particular files for the patients for the claims that you're trying to get paid on, it's a pretty good indication that the insurance carriers think that you're doing something wrong and may be looking at you for fraud. The other telltale sign is a request for an EUO. Sometimes the EUO request, which stands for an examination under oath, sometimes the EUO request will come with the verification request, and they'll be in the same letter. Sometimes you'll respond to the verification by giving the documents that they're looking for. And if the insurance companies are not satisfied with the documents, they will send the EUO request after that. Once these requests are made, generally your reimbursement is going to be frozen. And what that means is any of the claims that you've submitted that are under investigation, and generally any of the claims that you've already submitted that are in the pipeline but haven't been formally included in a verification notice, are also going to be frozen, which means none of your claims are going to be processed and paid until the insurance carrier is satisfied with their response to the verification, or until they're satisfied with the testimony that you give during an EUL. So an important thing to remember is, even if you do these best practices and you get the verification responses, one way to kind of save yourself harassment is to go to an experienced healthcare attorney before you set up your practice. That way you can make sure that all of your leases are in place and are appropriate, your operating agreements, your billing agreements, your marketing contracts, if you have any, because that will make your attorney's life much easier once you're served with a verification notice or an EUO notice. Because if you go to the same healthcare attorney, or the same firm, at least, that set up your practice to begin with, they're going to have a very good idea of the types of things that the carriers may be looking for, and it gets your attorney going quicker and it ends up being much more economical. And usually, if you've gone to a reputable healthcare attorney, they'll be able to go to the insurance carriers and say, hey, look, I know you're questioning these claims, but you're really barking up the wrong tree. Let me show you all the goods, and let's see if we can avoid the EUO and get my client paid. Now, if that's not the case, and you haven't gone to a healthcare attorney before, and you get a verification notice or an EUO notice, the first thing that you do is to run to your attorney's office. Okay. You don't want to just say, I'll give them the documents that they're looking for. I'll just show up for this EUO. I know lots of my friends in the industry, they've gotten EUO'd all the time. They don't get a lawyer. They show up, they answer the questions. I don't think it's such a big deal. Well, trust me, if you want to stay out of a RICO case, and most important, you want to get paid, it is a big deal. So please make sure that you contact an experienced EUO litigation attorney, specifically one who has experience defending RICO cases. You will find that the process will go much smoother for you and will have a better outcome, and hopefully keep you out of being named in a RICO suit to begin with. So, what should you do once you get served with the EUO notice and you have contacted your attorney? You need to prepare. I cannot stress this enough. Preparing for the EUO, in my view and in my experience, is probably the most important thing that you can do in an effort to keep yourself out of the RICO case. You should meet with your attorneys several times before your scheduled date for the EUO. You should go over the documents that you've given. You should discuss with your attorney why he or she thinks they've asked for the documents they've asked for. And there are certain particular categories of items for testimony that you should be going over with your attorney kind of ad nauseum. There really is no such thing as being over prepared for these, because a good prosecutor for the insurance is going to really, really nitpick and ask questions that you would never think that they would ask during these EUOs, because they're really trying to unravel threads, to look at your connections, to look at your business practices, to see if they think there's fraud. And let's not forget, fraud is a difficult thing to prove. So in order for the insurance carriers to include you in a RICO case, they really have had to have done their homework before they put you in these EUOs, and they're going to ask you some really in-depth questions. So let's go over a couple of things that you really should be familiar with and be able to answer during an examination under oath. The first thing is your offices. What do I mean by that? Know where they are. I know that sounds kind of elementary, but when you have your hands in a lot of different practices, and if you have a lot of lease agreements or sublease agreements, and maybe you're only in one location for, once a week or even once a month, you may not remember offhand all of them. So be familiar with the addresses of your offices. Be familiar with the office layout of each location. And by that, I mean, know the details, how many square foot you have, where the location of your office is within the space. Do you have any equipment there? Where's the front desk? Where are the restrooms located? What does it look like to get from the outside of the building inside the building? Is there a staircase you have to go up? What floor is it on? All sorts of in-depth questions about the offices I've seen asked time and time again. And when people are unable to answer those questions, the insurance companies sort of think, well, maybe this person really isn't at this office as often as they think they are, which is a curious thing because their name is on all the bills. So make sure that you really understand what the offices look like. The next thing you need to know is your leases. Know your lease agreements sort of inside and out. And what I mean by that is you have to know the amount that you're paying in rent, which, by the way, has to be a flat fee. You should not be paying a different amount on your lease one month to the next month, because it could look like you're paying a percentage based on the amount of money that you're generating and splitting it with the landlord, which, if it's another physician, is fee splitting. So definitely know your lease amount. Definitely know how long the lease is for, the term. Know your renewal terms. Know the name of your landlord. There have been several times where I've had questions asked, well, who do you lease the space from? If you don't know the answer to that, that really does make it look like it's not a legitimate lease. It's also very important, going back to the rent amount, to make sure that your know that it's a flat fee and how much it is every month. Make sure that you know all of your employees. And by that, I mean their names, their positions, how long that they've been there, where you acquired them from, the types of services that they do. Make sure that you're familiar with the services that you provide, and how much you bill for each service and what codes you use and what the justification for those codes are. Make sure that you're familiar with who does the paperwork in the office, who does the billing, who signs off on all the expenses, who's in charge of financials, where do you get your referrals from? And a very, very important point is make sure that at any place where you're subleasing or leasing, you are able to schedule your own patients there. Because if all you're doing is paying a flat fee in rent to another physician and you're not able to schedule your own patients and you're really just there to see their patients, insurance carriers look at that as if it's not a real lease and you're really just paying for access to patients. And then that allows you to bill without actually having a leased space. In other words, it's more like a pay to play scenario, which can very easily land you in a RICO case.
So as Justin discussed, EUO preparation is really hugely important. And I can tell you from experience in taking these EUOs that bad answers during an EUO can absolutely lead you into a RICO case. And as Justin was kind of alluding to just a moment ago, there are certain things that insurance companies are trying to look for and seeing if they can build a RICO case against a certain provider. So for example, one of the things that Justin was just talking about is this idea of paying for patients. It's commonly referred to as kickback arrangement. So basically any situation in which a provider is getting their patients or getting access to patients from non-medical personnel. So that's one thing that these insurance companies are trying to look for, any evidence of that. In addition to that, they're looking to attack the medical necessity of any treatments that you are providing or billing for. Because if they can attack the medical necessity of the treatments, they can argue they don't have to pay you. So these are some of the common questions that on their face may seem pretty innocuous, but depending on your answer, if you're not prepared, these answers can be pretty damning and lead to a RICO case. So for example, like Justin asked, how do you get your patients? Are 100% of your patients coming from other providers at the clinic where you're operating from? Well, that's going to raise a huge red flag, because if you're not conducting any outside advertising or any outside marketing and you have no website and you have no address listed online, how are these 200 patients a month finding you? Are all of them coming from inside this clinic? If so, that's going to be a red flag. So as Justin said, if you have the ability to bring your own patients to the clinic, you need to make sure that you say that during the course of your EUO. As I mentioned before, do you advertise for your services? It doesn't have to be through social media, but a website goes a long way. An email address, business cards, flyers. If you use any kind of outside marketing or advertising agency, those are important things to note during the course of your EUO. As Justin mentioned before, what are the terms of your lease? What is the amount of your rent? If, for example, you're renting, a room from one location and you're paying $5,000 a month to be there once a week, that might lend itself to an inference that you're paying for these patients because you're only there 4 times a month and yet you're paying over 1,000 times per, instance where you're at that location. So make sure your rent amount is a fair market value, and so that inference cannot be drawn. As I mentioned before, do you have agreements with other entities, billing companies, transportation companies, advertising, marketing, consulting companies? Make sure these are legitimate companies. Do your research. You would expect that an advertising company or a marketing company is at the very least going to have a website or social media presence. And oftentimes in my experience, we've seen providers pay for these services and these companies don't exist. We can't find a footprint from them anywhere. So make sure if you are using these types of companies, they are legitimate companies with paper trails. Which brings me to the transportation companies. Best practice, just don't use them. Don't use them. Patients can provide for their own transportation. If there is a situation where you absolutely needed to help a patient out, try Uber or Lyft or something like that. But these ABC transportation company, XYZ transportation company, best practice is just to not use them and not engage with them. Similarly, you may be asked if you have appropriate certifications or qualifications. This comes up a lot during the context of a DME provider. Are you billing for custom fitted or custom fabricated items? If so, do you have the appropriate qualifications, or do your employees? So make sure you keep records of those and you're prepared to answer those questions.
And one other thing to discuss briefly, just to build on this, when you're at the EUOs, you will often be asked questions about particular services that you provide. You need to be able to stand by the services and explain why they're medically necessary, because the insurance carriers will take a look at any of the services that they feel can be abused. And what I mean by that are services where they feel they're not the type that would normally be rendered by legitimate practices, and tests that can be compensated under the no-fault codes in a very high amount. And if you think about it, those are the ones that the insurance carriers are not going to want to pay, and also the types that they look at to put you into RICO cases. So it's very important for you to be able to say, yes, I do this test. This is why I do the test. I think it's very helpful. This is how I think it helps the patients. These are the scenarios where I do them. I don't do them every single time. This is why I bill the amount I bill, because that's what the fee schedule says. And it might be very good to have some sort of literature handy where you can cite to and say, in fact, there's been a study by Dr. X, Y, and Z who has said that this particular type of test is very helpful for patients, especially 30 days out of an accident or 10 days out of an accident. And I often do it when I see this particular situation, and I find it to be very helpful. Because one of the things that RICO cases target is services that are provided that are not medically necessary and are just done for the sake of doing it because of the amount of compensation that's tied to it. So you should be able to really express during the EUOs why you're doing particular tests, why they're important, why they're medically necessary. Now, skipping to after the EUO, what generally happens is a carrier is then going to send your attorney what's called as a post-EUO verification notice. Generally what that is certain documents will have been asked for during the EUO that either weren't produced or that your attorney has advised not to produce, and the insurance carriers will follow up after the EUO and say, now that we've completed and reviewed your testimony, here are the documents that we were looking for. We don't consider this investigation closed unless and until you provide us the documents. There are certain documents that will be asked for potentially during the EUO, which are credible and actually could help your case. And if your attorney tells you to turn them over, then you probably should. But there are others where, generally speaking, we're not going to have them turned over, at least not my clients. And those are bank records, information pertaining to your bank account, branch locations, tax returns, K-1s, partnership statements, your 1099s for your employees, and your W-2s. And the reasons why I'm generally not turning those documents over is they generally have nothing to do with a review of the actual claims that are in verification protocol. And what you don't want to do is lend to a fishing expedition by the insurance carrier to give them information that allows them to look deeper into your practice and perhaps find something that they didn't ask during the EUO, which can also, unfortunately, get you put into a RICO claim. In my view, unless those documents are 100% clean and they've been reviewed by your attorney, and maybe your attorney can get them to the other attorney through an attorney's eyes only scenario, I generally do not turn those over under any circumstance. And in most cases, the insurance carriers will move on after some pushback and not require them. And you'll either settle the EUO and get paid, or if you get into the RICO case, unfortunately, at least you're doing so without that documentation in the insurance carrier's hands, which could give them an advantage going forward.
So just to bring everything that we've kind of discussed full circle, the best way to think about these RICO cases and everyone's respective involvement in the RICO cases is to think of them as symbiotic relationships. Basically, everyone who is alleged to be part of a RICO scheme is going to benefit from the role of everyone else. As Justin mentioned previously, these cases carry with them joint and several liability. So it kind of doesn't matter if you were only responsible for, say, a 2% or 3% portion of the overall fraudulent scheme. If you're involved, you're involved. And that's how they like to tie these cases together, is because you maybe got one or two referrals from this doctor that they're really looking at, or you maybe wrote, an MRI script to this one MRI facility that they're really looking at. They're looking at specific instances where they have reason to believe that, a particular clinic is being controlled by somebody who's a non-medical personnel, and that person is giving access to providers to the patients at that clinic in exchange for the rent payments. And, because they know that there are set reimbursement rates, these non-licensed clinic controllers are able to set the terms of what providers can bill for and what services can be billed for, so that they can get the most reimbursement they can from these insurance companies. So, when you look at the different ways that these insurance companies are trying to put these cases together, and you think about how beneficial for them an EUO testimony can be and documents provided for that, you can then understand why lack of preparation it can be so detrimental to your cause, because you're basically giving them just the preview of what the case could be, and you're giving them, the different pieces that they can put together to make this big puzzle. And they can, from that information, from that testimony, from that documentation, they can try to look for the patterns, the existence of the enterprise, and the appropriate racketeering activity, which usually they're going to rely on the submission of bills and the supporting documentation to make out.
And after all of that and all the preparation and going through the EUO and providing the documents, if unfortunately you do find yourself named in a RICO case, the first thing you should do is not panic. Just because it says racketeer influence criminal organization, it doesn't mean that you're being accused of a crime, although it can happen, but 99.9% of the time when it comes to medical providers, we are talking about civil claims. The first thing you should do is contact your attorney. Make sure that you contact an attorney who has significant experience handling RICO defense. It is a specialized type of litigation. You shouldn't be going to, someone who just does collections, or maybe someone who just handles your arbitrations. Make sure it's someone who knows how to defend these types of cases. And the third thing you should be doing is retaining all the records that are related to everything that we've discussed today, and everything that has to do with any of your specific cases that are named in the complaint. The good news is that the vast majority of these cases settle and don't end up going to trial. But of course, they're not the most pleasant thing to deal with. But if you go to an experienced attorney, they can generally guide you through it.
Absolutely. And obviously, if you have any questions about anything we've discussed today, or any particular hypotheticals that you may have, we will be available during the Q&A to answer any questions you may have. And I will briefly go to some slides with our contact information as well.
And Alexa and I would be available to discuss anything else you may want to bring up with regarding to RICO, or something more in depth in the particular elements of a RICO charge. Even if it's not something that's raised during the Q&A, you could always contact us at the office.
Absolutely. We're available always to answer any questions you have in this area.
We hope this was informative. Enjoy the rest of the conference.